starting in 5 seconds. The plaintiffs claim that the Indian defendant number 2 company is under the control of wrongdoers. They further claim that defendant numbers 8 to 10 were in active collusion with defendant numbers 3 to 7 and that they have joined hands to deprive defendant number 2 of its beneficial interest in the suit share, namely 6% of shares of the Indian company. The plaintiffs have further stated that they came to know from newspaper reports that the equity of defendant number 1 was to be sold to private equity investors through a bidding process and that defendant numbers 3 to 7 along with the defendant numbers 8 to 9 were attempting to sell their investments in the Indian company. It was urged that in case such a sale was to happen, defendant number 2, which had financed the purchase of such shares, would be put to loss if its beneficial interest was not recorded in the books of the Indian company. While filing the suit, and the plaintiffs had filed application number 292 of 2018 seeking leave to institute the suit within the jurisdiction of the High Court of Judicature at Madras. In the affidavit filed in support of that application, the plaintiffs had stated that they had sought a declaration that defendant number 2 had a beneficial interest over 6% of shares of the Indian company. However, the shares might be alienated. It was further stated that substantial part of the cause of action arose within the jurisdiction of the court where the registered office of the first defendant was located and where it carried on business. Further, the entire subject matter of the suit was the shares of the Indian company which are held by defendant numbers 3 to 7 and that defendant numbers 3, 5, 6 and 7 normally reside in Chennai. It was further stated that the correspondences between the plaintiff number 2 and the Indian company through defendant number 10 also took place in Chennai, claiming on this basis that substantial part of the cause of action arose within the jurisdiction of the High Court. Leave to institute the suit was sought. The single judge court granted leave. As noted above, the contested defendants filed applications for revocation of the order granting leave to the plaintiffs. The Indian company in the affidavit filed in support of A number 1387 of 2018. It was urged that order granting leave should be revoked on this ground itself. It was further stated that there are no disputes with respect to the ownership or management or shareholding of the Indian company. It also took the stand that the plaintiffs are neither the shareholder nor the directors of the Indian company and therefore they had no right to sue and consequently the suit itself is not maintainable. It also averred that the disputes between the plaintiffs and defendant numbers 3 to 7 arose around 2013 and the suit had only been filed in the year 2018 and consequently the suit was barred by limitation. Another objection was that the plaintiffs had filed the suit when private equity investors had shown interest in purchasing shares of the Indian company and the same was an abuse of process of law. Maintainability of the suit was also questioned on the ground that it was barred by Section 89 of the Companies Act 2013 and Section 180C 7C of the Companies Act 1956. Somewhat similar stand was taken by other contesting defendants in supporting of the prayer for revoking the leave and to rejecting the plaint in CS number 33 of 2018. Defendant number 2 also took the plea that it was not interested in seeking the relief claimed in the plaint. Defendant number 2 is the beneficial interest holder of 6% of shares of the Indian company. Counter affidavits were filed by the plaintiffs with respect to these applications, reiterating that they had the locus that the suit is within the period of limitation, that the court had jurisdiction to adjudicate the issues, and that the suit that had been filed with bona fide intent. The learned single judge dismissed the applications filed by the defendants seeking to revoke the leave granted to institute the suit and to reject the plaint inter alia, holding that the allegations pertaining to fraud would have to be decided in the suit. He further observed that there were factual issues that were to be gone into, and sections 187C and 89 of the Companies Act, which may be bar the reliefs but would not bar the suit. The aforesaid order of the learned single judge has been reversed by the division bench wide common judgment dated August 03, 2018. It has allowed the appeals filed by the contesting defendants and set aside the common order of the single judge, thereby revoking the leave granted by the single judge in the case. Stop. Starting in 5 seconds. In the light of the legal position stated herein above, it is very clear that no tax on the sale or purchase of goods can be imposed by any states when the transaction of sale or purchase takes place in the course of import of goods into or export of the goods out of the territory of India. Thus, if any transaction of sales or purchase takes place when the goods are being imported in India or they are being exported from India, no state can impose any tax thereon. Section 5 of the Central Act deals with the transaction which is said to have taken place in the course of import or export. Relevant portion of Section 5 of the Central Act reads as a sale or purchase of goods shall be deemed to take place in the course of the import of the goods into the territory of India only if the sales or purchase either occasions such import or is affected by a transfer of documents of titles to the goods before goods have crossed the customs frontier of India. Upon perusal of the aforestated provision of Section 5 of the Central Act, it is clear that a sale or purchase of goods shall be deemed to take place in the course of import of the goods into the territory of India only if sale or purchase takes place before the goods have crossed the custom frontier of India. Looking to the aforestated legal position, it cannot be disputed that the goods sold at duty-free shops owned by the appellant would be said to have been sold before the goods crossed the custom frontier of India, as it is not in dispute that the duty-free shops of the appellant situated at the international airport of Bengaluru are beyond the customs frontier of India. They are not within the custom frontier of India. If this is the factual and legal position, in our opinion, looking to the provisions of Article 286 of the Constitution, the state of Karnataka has no right to tax any such transaction which takes place at the duty-free shops owned by the appellant which are not within the custom frontier of India. Looking to the aforestated simple and factual legal position, in our opinion, it would not be much useful to discuss the judgments which have been referred to. In our opinion, the legal position is so clear that it was not necessary for the learned counsel to refer to any judgment, and merely by showing the aforestated factual aspect and legal provisions to the concerned authority, the appellant could have convinced the concerned authority that the sale effected at the duty free shops of the appellant could not have been taxed by the state of Karnataka. Learned counsel appearing for the respondent authorities had vehemently submitted that the appellant had not exhausted equal efficacy alternative statutory remedy, and therefore the single judge of the High Court had rightly not entertained the petition filed by the appellant. According to them, the division bench had also rightly dismissed the appeal of the same reason. According to them, this court also should not entertain this appeal. It is true that the appellant had rushed to the High Court without exhausting equal efficacious alternatives statutory remedy. In our opinion, the learned single judge of the High Court was also right when he directed the appellant to move the statutory appellate authority. In normal circumstances, even we would have expressed the same opinion, but looking to the fact that the special leave petition has already been admitted and the matter pertains to the assessment year 2004-2005, it would not be in the interest of the justice to relegate the appellant to the statutory authorities, especially when the legal position is very clear and the law is also in favor of the appellant. The learned counsel appearing for the respondent had submitted that the sale would not be taxed under the Act only if it occasions in the course of import, but the transactions of sale which are subject matter of this litigation had not taken place in the course of import, and therefore they would not be exempted under the provisions of Section 5 of the Central Act. In our opinion, the aforestated submission cannot be sustained. They again submitted that in the course of import means the transaction ought to have taken place beyond the territories of India and not within the geographical territory of India. We do not agree with the said submission. When any transaction takes place outside the customs frontier of India, the transaction would be said to have taken place outside India, though the transaction might take place within India, but technically looking to the provisions of Section 2 bracket 11 of the Customs Act and Article 286 of the Constitution, the said transaction would be said to have taken place outside India, the goods that are imported into the territory of India. Stop. Starting in 5 seconds. The plaintiffs submit that the present plea relates to the denial and non-recognition of the beneficial interest of defendant number 2 of the shares held by the defendant number 3, 4, 5, 6 and 7 in defendant number 1. The cause of action arose on 31st December 2016 when the draft consolidated financial statement of defendant number 11 records deconsolidation of its accounts with those of defendant number 2 for the reason that there is absence of confirmation of beneficial ownership from the legally registered shareholders of the entities. Thus, on 31st December 2016, it became manifested that the recordal of declaration of beneficial interest of the defendant number 2 would no longer be caused to be made by those in control of defendant number 2 and its affair, namely defendant number 3, 4, and 7, and which hostile action led to not only the denial of the recording of the beneficial interest of the defendant number 2 but also to deconsolidation with retrospective effect of its accounts with defendant number 11. With the deconsolidation of accounts, it became clear that a hostile action denying the beneficial interest of defendant number 2 stood taken by defendant number 3, 4, and 7. The cause of action further arose on 7 July 2017 when defendant number 1 refused to acknowledge the beneficial interest in the suit shares. The cause of action further arose when defendant number 1 through defendant number 10 on 27 July 2017 once again refused to acknowledge the beneficial interest in the suit shares. The cause of action further arose on 12 November 2017 and 24 November 2017 when newspaper articles being in public knowledge suggested that the equity of the defendant number 1 is being sold to private equity investors through a bidding process and the present investors including the defendant number 3 to 7 along with the defendant number 8 and 9 are attempting to sell their investments in the defendant number 1 and exit the health insurer. The cause of action further arose on 21 December 2017 when newspaper articles of the Economic Times being in public knowledge suggested that the 5 companies have been shortlisted to purchase the defendant number 1 and that the floor price of 5500 crore has been put for the sale by the defendant number 1. The plaintiff thus wanted to declaration to the effect that shares in the Indian company which are held by defendant number 3 to 7 in fact belong to defendant number 2 company. Since defendant number 2 did not come forward to make the said claim, derivative action was filed by the plaintiffs on its behalf to the aforesaid effect. As per the plaintiffs, the High Court of Madras at Chennai had the jurisdiction to entertain the same inasmuch as one registered office of the Indian company is in Chennai. 2. The investments made by the defendant number 2 were made in the Indian company in Chennai, and 3. Substantial part of cause of action as reflected in the correspondence letters exchanged between plaintiff number 2 and defendant number 1 and 10 arose in Chennai. The contesting defendants questioned the territorial jurisdiction of the Madras High Court to entertain the said suit on the ground that no cause of action available to the plaintiffs to maintain the suit arose within the jurisdiction of the said court. In substance, the plaintiffs were attempting to resolve the dispute between the shareholders of the company, though all these shareholders are residents and national of Dubai. Moreover, they are claiming that those shares are in the names of defendants number 3 to 7. It is defendant number 2 which has the beneficial interest therein, and even defendant number 2 is a foreign entity which is covered by the foreign law. Likewise, the inter se relationship between defendant number 2 and the plaintiffs is also covered by the foreign law. It was additionally contended that the claims made by the plaintiffs are not enforceable even under the Companies Act 1956 or the Companies Act 2013. As far as inter se disputes between the plaintiffs and the contesting defendant, who are all shareholders of defendant number 2, are concerned, they have arisen in Dubai, which is outside the territorial jurisdiction of Chennai. Mrs. C.A. Sundaram, Neeraj, Krishan Kaul, and other learned senior counsel appeared for the plaintiffs. In substance, their argument was that the learned single judge of the Madras High Court had rightly allowed the application for leave to file the suit after satisfying that the court at Chennai had the territorial jurisdiction to entertain such a suit, which was derivative action taken out by the plaintiffs on behalf of the defendant number 2. It was highlighted that even if defendant number 2 was a Dubai company, of which plaintiffs and defendant number 3 to 7 were the shareholders, dispute was in respect of shares in defendant number 1, which was an Indian company having its registered office in Chennai from the date of its incorporation. Stop. Starting in 5 seconds. Sir, as the Honorable Minister has already made it clear that this bill has been brought forward for our consideration after due consultation with the central trade unions, and this bill has been necessitated by the fact that the amendment in the Industrial Disputes Act in 1982 exclude the workers in hospitals and other educational institutions from the purview of the Act. This means that a hospital or an educational institute cannot be called an industry, and if it cannot be called an industry, all those who are working in those institutions cannot get the benefit from the Industrial Disputes Act of any kind. So, naturally, something has to be done for all those employees of such institutions for the redressal of their grievances. It is exactly for this that this bill has been brought before us for our consideration. As regard this bill, there is a provision for setting up of a grievances redressal authority and appellate authority in all establishments for the redressal of industrial disputes. As regards the collective grievances, management council are proposed to be there. Naturally, this has to be done by employer or by those who actually are managing those institutions. If the government is the proprietor, then the government has to do it. If it is a private hospital or a private educational institution, whoever is the employer has to do it, and doing it has been made statutory by this bill. It will be the bounden duty to evolve such machinery for redressal of the grievances of the employees and other employees therein. So, since this bill has been brought forth in consultation with the concerned central trade unions, there is not much to oppose the content of this bill. We can, of course, earnestly hope that, as contemplated in the bill itself, very soon these appellate authority or grievance redressal authority or management council will be established in all such institutions, so that all those who are working therein may be able to get their genuine grievances redressed. As a matter of fact, last year our CGHS doctors went on strike in Delhi. Similarly, the PCMS doctors in Punjab also went on agitation. Somehow, these doctors, whether it is this state or that state, have been agitating and going on strike. Why do they go on strike? As a matter of fact, they do not enjoy the right to strike, just as university teachers, about whom I made a special mention today only. Again, they are going to agitate. Why do they go on strike? Although they do not have the right to strike, why do they go on strike? This is what I am saying. You listen to me. They go to strike compelled by circumstances when they are not able to get justice, economic and social due to them, then whether you give them the right to strike or not, whether it is on the statute books or not, the workers, the wage earners must take that action ultimately. You cannot check them, and you have not been able to check them. After all, you have to come to terms with them. An agreement was signed, an accord was there in the case of university teachers, but that accord has not been implemented as yet. Those universities, teachers, and employees are also covered under this bill. That is why I am mentioning this. As regards doctors, of course, much has been done to give them justice. Still, they are not happy. It is the attempts of the government to keep the medical institutions, the educational institutions free from conflict as far as possible so that they do not have to agitate every now and then, and there is an alternative mechanism provided for where they can take their grievances. As regards individual grievances, of course, you go on strike for collective grievances, not for individual grievances. The grievance redressal authority for the appellate authority that is being provided for is alright. It is only in the case of collective grievances that trade union activity comes into the picture, but that also comes into the picture if necessary. Otherwise, if the collective grievances can also be met through negotiations, through arbitration, and in other ways, then the question of direct action may not arise at all. So, at least so far as individual grievances are concerned, this will go a long way in settling them and keeping the working force happy. As regards collective grievances, also, I personally think that the mechanism that is now being provided for will go a long way to eliminate conflicts. What I mean to say is that so far as hospitals are concerned or educational institutions are concerned, I would request the government to make all possible efforts to extend the justice due to them. They must have justice if they can get it, like other personnel in services. Stop. Starting in 5 seconds. Madam, I beg to move that the bill to provide for the redressal of grievances of employees in hospitals and certain other institutions and for matters connected therewith or incidental thereto be taken into consideration. Madam, as you are aware, following the judgment of the Supreme Court in the Bangalore Water Supply and Sewerage Board case, which gave a very wide interpretation to the term industry under the Industrial Disputes Act 1947, the definition of the term industry was revised so as to exclude, among others, hospital or dispensaries, educational, scientific, research, and or training institutions, institutions owned or managed by organizations wholly or substantially engaged in any charitable, social, and philanthropic service, khadi, or village industries, any activity of the government relatable to the sovereign functions of the government, including all the activities carried on by the Department of Central Government dealing with defense research, atomic energy, and space. Madam, this was necessary because these are the areas which we felt should be free from strikes or stoppages of work, etc. In the interest of journal public promotion of voluntary effort, efficient discharge of the sovereign functions, administrative, legislative, and judicial of the government, and also with a view to protecting vulnerable sections of industry. While most of the provisions of the said Amendment Act of 1982 have been enforced, the said section 2 bracket E could not be enforced because it was felt that before excluding certain establishments or institutions from purview of the Industrial Disputes Act, there must be an alternative grievance redressal machinery for the employees employed therein, or else their exclusion without at the same time providing for a suitable alternative machinery might be open to challenge as being discriminatory and violative of Article 14 of the Constitution of India. It was with this objective in mind that the then Minister of State for Labor introduced in this House the Hospitals and Other Institutions Settlement of Disputes Bill on 6th May 1992. Divergent points of view were expressed in the course of the debate on this bill. Representatives of the voluntary organization, etc., were also heard, and the then minister gave an assurance that he would discuss the matter with the trade union leaders. In pursuance of that assurance, meetings were held with the representatives of the central workers' organizations in July August 1995. In the light of the discussions held with different persons concerned, we have now brought forward another bill which is much simpler than the previous one and embodies for the employees concerned a machinery which would be largely internal to each organization. The bill which is now before the House is in pursuance of government's desire to provide for a proper procedure and machinery for the redressal of individual and collective grievances. The arrangements proposed are more conducive and less cumbersome than the procedure incorporated in the Industrial Disputes Act 1947. This bill provides for two types of machinery, one for the redressal of individual grievances and the other for collective grievances. Individual grievances will be looked into by the grievance redressal authority against whose orders an appeal will lie to the appellate authority. If any aggrieved party is not satisfied with the decision of the grievance redressal authority or the appellate authority, it is free to approach an independent tribunal whose decision would be binding. All these authorities would be required to pass an order within a specified time. As regards collective grievances, these would be looked into by a management council, a bipartite machinery comprising the representatives of the employers and the employees. Where a management council fails to settle any collective grievance within a specified period, there is a provision for reference of the grievance to an agreed arbitrator, failing which the grievance could be referred to a board of arbitrators headed by a judicial officer appointed by the appropriate government. In order to give relief to the smaller establishment, we do not propose to apply the proposed legislation to establishment employing less than 10 persons. We also propose to exclude from its purview establishment owned or controlled by government. This provision has been made owing to the fact that government employees can take recourse to administrative or similar tribunals in individual matters, and JCM or JCM type machinery in collective matters. We also propose to exclude societies registered under the Societies Registration Act 1860 subject to certain conditions, one of these being that if they are entirely financed by the government, they would be excluded. Besides, educational institutions will cease to be covered in due course as and when the appropriate government makes a law for the redressal of grievances of employees. The government will have the power to exempt any establishment from its purview. Stop. Starting in 5 seconds. Honorable Speaker, sir, I take this opportunity to thank all the taxpayers of our country who have contributed immensely and strengthened the hands of the government in helping their fellow citizens in this hour of need. Drawing wisdom from our ancient text, we continue on the path to progress. The proposals in this budget, while continuing with our declared policy of stable and predictable tax regime, intend to bring more reforms that will take ahead our vision to establish a trustworthy tax regime. This will further simplify the tax system, promote voluntary compliance by taxpayers and reduce litigation. India is growing at an accelerated pace and people are undertaking multiple financial transactions. The Income Tax Department has established a robust framework of reporting of taxpayers' transactions. In this context, some taxpayers may realize that they have committed omissions or mistakes in correctly estimating their income for tax payment. To provide an opportunity to correct such errors, I am proposing a new provision permitting taxpayers to file an updated return on payment of additional tax. This updated return can be filed within 2 years from the end of the relevant assessment year. Presently, if the department finds out that some income has been missed out by the SSC, it goes through a lengthy process of adjudication. Instead, with this proposal, now there will be a trust reposed in the taxpayers that will enable the SSC himself to declare the income that he may have missed out earlier while filing her return. Full details of the proposal are given in the Finance Bill. It is an affirmative step in the direction of voluntary tax compliance. Currently, cooperative society are required to pay alternative minimum tax at the rate of 18 and 1/2%. However, companies pay the same at the rate of 15%. To provide a level playing field between cooperative societies and companies, I propose to reduce this rate for the cooperative societies also to 15%. I also propose to reduce the surcharge on cooperative societies from present 12% to 7% for those having total income of more than rupees 1 crore and up to rupees 10 crore. This would help in enhancing the income of cooperative societies and its members who are mostly from rural and farming communities. The parent or guardian of a differently abled person can take an insurance scheme for such person. There could be situations where differently abled dependents may need payment of annuity or lump sum amount even during the lifetime of their parents or guardians. I propose to thus allow the payment of annuity and lump sum amount to the differently abled dependent during the lifetime of parents or guardians, that is, on parents or guardians attaining the age of 60 years. At present, the central government contributes 14% of the salary of its employee to the national pension system. This is allowed as a deduction in computing the income of the employee. However, such deduction is allowed only to the extent of 10% of the salary in case of employees of the state government. To provide equal treatment to both central and state government employees. I propose to increase the tax deduction limit from 10% to 14% on employers' contribution to the NPS account of state government employees as well. This would help in enhancing the social security benefits of the state government employees and bring them at par with central government employees. Startups have emerged as drivers of growth for our economy. Over the past few years, the country has seen a manifold increase in successful startups. Eligible startups established before 31st March 2022 had been provided a tax incentive for 3 consecutive years out of 10 years from incorporation. In view of the COVID pandemic, I propose to extend the period of incorporation of the eligible startup by one more year, that is up to 31st March 2023, for providing such tax incentive in an effort to establish a globally competitive business environment for certain domestic companies. A concessional tax regime of 15% tax was introduced by our government for newly incorporated domestic manufacturing companies. I propose to extend the last date for commencement of manufacturing or production under Section 115B by 1 year, that is from 31st March 2023 to 31st March 2024. There has been a phenomenal increase in transactions in virtual digital assets. The magnitude and frequency of these transactions have made it imperative to provide for a specific tax regime. Accordingly, for the taxation of virtual digital assets, I propose to provide that any income from transfer of any virtual digital asset shall be taxed at the rate of 30%. No deduction in respect of any expenditure or allowance shall be allowed while computing such income except cost of acquisition. Further, loss from transfer of virtual digital asset cannot be set off against any other income. Further, in order to capture the transaction details, I also propose to provide for TDS on payments. Stop. Starting in 5 seconds. It has been observed that a lot of time and resources are consumed in filing of appeals which involve identical issues. Taking forward our policy of sound litigation management, I propose to provide that if a question of law in the case of an SSC is identical to a question of law which is pending in appeal before the jurisdictional high court or the Supreme Court, in any case the filing of further appeal in the case of this SSC by the department shall be deferred till such question of law is decided by the jurisdictional high court or the Supreme Court. This will greatly help in reducing the repeated litigation between taxpayers and the departments. Taking forward our efforts to further promote the IFSC, I hereby propose to provide that income of a non-resident from offshore derivative instruments or over-the-counter derivatives issued by an offshore banking unit, income from royalty and interest on account of lease of ship, and income received from portfolio management services in IFSC shall be exempted from tax subject to specified conditions. In the globalized business world, there are several works contracts whose terms and conditions mandatorily require formation of a consortium. The members in the consortium are generally companies. In such cases, the income of these AOPs has to suffer a graded surcharge up to 37%, which is a lot more than the surcharge on the individual companies. Accordingly, I propose to cap the surcharge of these AOPs at 15%. Further, the long-term capital gains on listed equity shares, units, etc. are liable to maximum surcharge of 15%, while the other long-term capital gains are subjected to a graded surcharge which goes up to 37%. I propose to cap the surcharge on long-term capital gains arising on transfer of any type of assets at 15%. This step will give a boost to the startup community, and along with my proposal on extending tax benefits to manufacturing companies and startups, reaffirms our commitment to Atmanirbhar Bharat. The income tax is not an allowable expenditure for computation of business income. This includes tax as well as surcharges. The health and education cess is imposed as an additional surcharge on the taxpayer for funding specific government welfare programs. However, some courts have allowed. Presently, there is ambiguity regarding set of brought forward loss against undisclosed income detected in such operations. It has been observed that in many cases where undisclosed income or suppression of sales etc. is detected, payment of tax is avoided by setting off of losses. In order to bring certainty and to increase deterrence among tax evaders, I propose to provide that no set-off of any loss shall be allowed against undisclosed income detected during search and survey operations. It has been noticed that as a business promotion strategy, there is a tendency on businesses to pass on benefits to their agents. Such benefits are taxable in the hands of the agent. In order to track such transactions, I propose to provide for tax deduction by the person giving benefits if the aggregate value of such benefits exceeds rupees 20,000 during the financial year. GST has been a landmark reform for independent of independent India, showcasing the spirit of cooperative federalism. While aspirations were high, there were huge challenges too. These challenges were overcome deftly and painstakingly under the guidance and oversight of the GST Council. We can now take pride in a fully IT driven and progressive GST regime that has fulfilled the cherished dream of India as one market, one tax. There are still some challenges remaining, and we aspire to meet them in the coming year. The right balance between facilitation and enforcement has engendered significantly better compliance. GST revenues are buoyant despite the pandemic. Taxpayers deserve applause for this growth. Not only did they adapt to the changes but enthusiastically contributed to the cause by paying taxes. In part A of my speech, I have referred to the proposed reforms in SEGs. Alongside, we will also undertake reforms in customs administration of SEGs, and it shall henceforth be fully IT driven and function on the customs national portal with a focus on higher facilitation and with only risk based checks. This will ease doing business by SEZ units considerably. This reform shall be implemented by 30th September 2022. Customs administration has reinvented itself over the years through liberalized procedures and infusion of technology. Faceless customs has been fully established. During COVID-19 pandemic, customs formation have done exceptional frontline work against all odds, displaying agility and purpose. Customs reforms have played a very vital role in domestic capacity creation, providing level playing field to our MSMEs, easing the raw material supply side constraints, enhancing ease of doing business, and being an enabler to other policy initiatives in the current year. Stop. Starting in 5 seconds. With effect from the date of taking possession of the site, the allotee or his heirs and successors shall be liable to pay the taxes, fees, and chassis payable in respect of the site and any building erected thereon, if the particulars furnished by the applicant in the prescribed application form for allotment of site are found incorrect or false. Subsequently, 12.5% of the site value shall be forfeited after the site is resumed by the board, and the balance amount of site value refunded to the applicant. Rule 18 likewise speaks about restrictions, conditions, and limitations on sale of sites, and we refer to the same. Restrictions, conditions, and limitation on sales of sites. 1. Notwithstanding anything contained in bracket A, these rules or any other rules, bylaws, or orders governing the allotment, grant, or sale of sites by the board for construction of buildings, or any instrument executed in respect of any site allotted, granted, or sold by the board for construction of buildings, the chairman may, at the request of the allottee, grantee, or purchaser of a site, execute a deed of convenience subject to the restriction, conditions, and limitations specified. The convenience by the chairman of a site in favor of an allottee, grantee, or purchaser of a site shall be subject to the following restrictions, conditions, and limitations, namely, in the case of a site on which a building has not been constructed. 1. The purchaser shall construct a building on the site within such period as may be specified by the board as per plans, designs, and conditions to be approved by the board or in conformity with the provisions of the City of Bangalore Municipal Corporation Act 1949 and the bylaws made thereunder. 2. The purchaser shall not without the approval of the board construct on the site any building other than a building for the construction of which the site was allotted, granted, or sold. 3. The purchaser shall not alienate the site within a period of 10 years from the date of allotment except by mortgage in favor of the Government of India, the Government of Mysore, the Life Insurance Corporation of India, or the Mysore Housing Board, or any corporation set up, owned or controlled by the state government or the central government to secure monies advanced by. In the case of a site on which a building has been constructed, the purchaser shall not alienate the site and the building constructed thereon within a period of 10 years from the date of allotment except by mortgage in favor of the Government of India, the Government of Mysore, the Life Insurance Corporation of India, or the Mysore Housing Board, or any cooperative society approved by the board to secure monies advanced by such government or society for the construction of the building on the site or with the previous approval of the board. In the event of purchaser committing breach of any of the conditions in clause or clause B, the board may at any time after giving the purchaser reasonable notice resume the site free from all encumbrances. The purchaser may remove all things which he has attached to the earth, provided he leaves the site in the state in which he received it. All transaction entered into a contravention of the conditions specified in clause A and B shall be null and void ab initio. Notwithstanding anything in sub rule 2, but without prejudice to the provisions of rule 17, where the lessee applies that for reasons beyond his control he is unable to reside in the city of Bangalore or by reasons of his insolvency, it is necessary for him to sell the site or site and the building, if any, he may have put up their own. The Bangalore Development Authority may, with the previous approval of the state government, either bracket A requires him to surrender the site where there is no building in its favor, or bracket B where there is a building put up, permit him to sell the vacant site and building, provided that bracket 1 in case covered by clause A, the Bangalore Development Authority shall pay to the lessee the allotted value of the site and an additional sum equal to the amount of interest at 12% per annum thereon, and in case covered by clause B, the lessee shall pay to the Bangalore Development Authority a sum equal to the amount of interest at 12% per annum on allotted value of the site. Rule 19 dealt with voluntary surrender and it read as follows: an allottee may at any time after allotment surrender the site allotted to him to the board. On such surrender, the board shall refund all amounts paid by the allottee to the board in respect of the said site. The rules did not apply to disposal of corner sites and commercial sites. Stop. Starting in 5 seconds. In Om Kumar and others versus Union of India, this court observed that the principle of proportionality was being applied to legislative action in India since 1950. Any challenge to restrictions imposed by the government under Articles 9(2) to 19(6) are tested by courts on the principle of proportionality. Whether restrictions placed are reasonable or not is adjudicated on the basis of appropriate balance between rights guaranteed and the control permissible under Article 19(2) to 19(6). When legislation is challenged on the ground the restrictions placed on the fundamental right is disproportionate, the court conducts a primary review where the state has to justify the necessity of restricting the fundamental rights. Proportionality involves balancing test and necessity test. The balancing test relates to scrutiny of excessive, onerous penalties or infringement of rights or interest and a manifest imbalance of relevant considerations, whereas the necessity test requires infringement of human rights in question to be by the least restrictive alternative. According to legal experts, proportionality in the broad sense is based on two principal components. The first is legality, which requires that the limitation be prescribed by law. The second is legitimacy, which is fulfilled by compliance with the requirements of proportionality in the regular sense. Its concern is with the conditions that justifies the limitation of a constitutional right by a law. There are two main justificatory conditions: an appropriate goal and proportionate means. An appropriate goal is a threshold requirement, and in determining it, no consideration is given to the means utilized by the law for attaining the goal. a goal is appropriate even if the means of attaining it is or not. The proportionate means must comply with three secondary criteria: a national rational connection between the appropriate goal and the means utilized by the law in attain it. B. The goal cannot be achieved by means that are less restrictive of the constitutional right. C. There must be a proportionate balance between the social benefit of realizing the appropriate goal and the harm caused to the right. The three tests of proportionality propounded by Dictations in R versus Ox are: A. The measures adopted must be rationally connected to the objective. B. The means should impair as little as possible the right or freedom in question. C. There must be a proportionality between the effects of the measures and the objective. K. Shikri, Justice in Modern Dental College and Research Center and others versus State of Madhya Pradesh, remarked that the doctrine of proportionality is enshrined in Article 19 itself. He explained that the expression restrictions seek to strike a balance between the freedom guaranteed in Article 19 bracket 1 and social control permitted by Article 19 bracket 2 to 19 bracket 6. It was further held in Modern Dental College and Research Center and others versus State of Madhya Pradesh that limitations imposed on the enjoyment of a right guaranteed under the Constitution should not be arbitrary or excessive to what is required in the interest of public. It is also relevant to refer to the following factors which have to be kept in mind for examining the reasonableness of a statutory provision as laid down in MRF Limited versus Inspector Kerala Government. The basis of various decisions of this court, the following principles are clearly discernible. While considering the reasonableness of the restrictions, the court has to keep in mind the directive principles of state policy. Restrictions must not be arbitrary or of an excessive nature so as to go beyond the requirement of the interest of the general public. In order to judge the reasonableness of the restrictions, no abstract or general pattern or a fixed principle can be laid down so as to be of universal application, and the same will vary from case to case, as also with regard to changing conditions, values of human life, social philosophy of the constitution, prevailing conditions, and the surrounding circumstances. A just balance has to be struck between the restrictions imposed and the social control envisaged by clause 6 of Article 19. Prevailing social values as also social needs which are intended to be satisfied by restrictions have to be borne in mind. There must be a direct and proximate nexus or a reasonable connection between the restrictions imposed and the object sought to be achieved. If there is a direct nexus between the restrictions and the object of the act, then a strong presumption in favor of the constitutionality of the act will naturally arise. It is pertinent to refer to the observations made by Justice M. Jagannatha Rao in Om Kumar and others versus Union of India regarding proportionality in connection with Article 14 of the Constitution of India, which are as under. So far as Article 14 is concerned, the courts in India examined whether the classification was based on intelligibility differentia and whether the differentia had a reasonable nexus with the object of the legislation. Obviously, when the court considered the question whether the classification was based on intelligible differentia, the courts were examining the validity of the differences and the adequacy of the differences. Stop.